Good morning, everyone. My name is Gerald Griffiths, and I'm here today with my colleague, Natasha Zervudakis. Thank you for joining us. A common refrain we frequently hear from employees is, "This violates my privacy," or "This violates my privacy rights." And the manner in which employees raise these issues, the venue in which they can pursue those, any rights they may have, and the types of issues they raise, as well as the rights themselves, are constantly changing. Today, Natasha and I are going to be speaking about new and emerging issues in this area of privacy law in the employment context. We have roughly 2,500 people registered for today's webinar, which goes to show the importance of privacy and the workplace. In terms of logistics for this morning, Natasha will start us off with a legislative update and speak about the issues of hiring, firing, and surveillance. And I will then, partway through, jump in and speak a little bit about the tort of intrusion upon seclusion. I'll then go on to speak about privacy and COVID-19, as well as what you should know about privacy policies. The format for this morning is as follows. Natasha and I are going to speak until roughly 10 a.m., and then we'll answer questions until 10:30 a.m. If you have questions for us, please type it into the Q&A box on your screen as we go, not in the chat box, which should be disabled. We'll do our best to answer as many questions as we can, but if we don't get to your questions, please reach out to us after the presentation. Finally, a recording of the presentation and the slide deck will be available on our website in a day or two. Let's get started. With that, I'll turn things over to Natasha.
Thank you, Gerald. Good morning, everyone. Thank you for joining us. I'm going to get started with the legislative update, but before I get there, I think it's important that we do a brief overview of the current state of privacy legislation across Canada before we get to the update. So I'll get us started there. The current landscape. So currently, the Privacy Act applies to federal government institutions. In terms of private sector privacy legislation, BC, Alberta, and Quebec all have passed their own private sector privacy legislation. In all other provinces, and with respect to federally regulated organizations, the Personal Information Protection and Electronic Documents Act, or PIPEDA, applies in addition to any other municipal and health-specific privacy legislation in place. So that's the current landscape. In terms of the update, we have Bill C11. And Bill C11 is federal legislation that's applicable to all organizations, save for express exemptions. And those exemptions include any government institution to which the Privacy Act applies, as well as potentially organizations in provinces which are deemed by order under the Act to have substantially similar legislation. What's important to note there is that there must be an order passed under this Act in order for that exemption to apply. Now, the long name of Bill C11 is a mouthful, and it's an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and to make consequential and related amendments to other acts. I will not be saying that throughout the presentation. The short title is the Digital Charter Implementation Act, which is also a mouthful, so I'll be referring to Bill C11 as Bill C11. And Bill C11 passed first reading on November 17th, 2020. So part one of Bill C11 is the Consumer Privacy Protection Act, the CPPA. And if passed, it will repeal and replace part one of PIPEDA. Now, it will maintain some of the fundamental components of PIPEDA. For example, the fundamental principles set out in PIPEDA will also be in the Consumer Privacy Protection Act. So the Consumer Privacy Protection Act will address making organizations accountable, making sure organizations collect information for appropriate purposes, limiting the collection, use, and disclosure of that information. The principle of consent will still be a fundamental part of the CPPA. The CPPA will address the retention and disposal of personal information, how to ensure accuracy, safeguarding information, openness and transparency with respect to that information, as well as individual access and how to challenge compliance. So those principles, which are covered in PIPEDA, will also be covered in the Consumer Privacy Protection Act. But the CPPA will also strengthen consumer protection and accountability and introduce more stringent enforcement mechanisms and harsher penalties for non-compliance. And I'll get to that in a second. Key components of Bill C11. One of the key components is that it requires organizations to implement a privacy management program in order to fulfill their obligations under the Act. And now that's going to apply to every organization. And the privacy management program will address the protection of personal information, will be required to address the protection of personal information, how requests and complaints are received and dealt with. The privacy management program will have to address training and information that is provided to an organization's staff with respect to its policies and procedures under the privacy management program. As well, organizations will be required to develop materials to explain their policies and procedures that it's put in place in order to fulfill their obligations. In addition, if requested by the commissioner, an organization will be required to provide the policies and procedures developed under its privacy management program. In addition to that, another key component is that the Bill C11 includes a duty to report and maintain records of any security breaches. Specifically contemplates that that reprisal against an employee for reporting a contravention is prohibited. In addition, it enhances consumer rights related to personal information held by an organization. Part 2 of Bill C11, the Personal Information and Data Protection Tribunal Act, establishes an administrative tribunal to hear appeals of decisions made by the Privacy Commissioner under the CPPA, and also to impose penalties for contraventions of certain provisions of the CPPA. And in terms of those penalties, and I said I would get back to this, the penalty could be up to $25 million or 5% of annual gross global revenues, whichever is greater. So we're talking about significant potential penalties for contraventions of certain provisions. So keep that in mind. In terms of a further legislative update, as I said, there currently is no private sector privacy legislation in Ontario. Historically, that means that PIPEDA has applied to commercial activity. Now, in late 2020, Ontario did launch a public consultation with respect to the potential for its own provincial privacy legislation. At the current time, there's no legislation in place or tabled, and it remains to be seen if it will be introduced in 2021. And that concludes the legislative update. I'm going to switch gears now and talk about privacy in the context of hiring, firing, and surveillance. With respect to hiring, specifically applicant information, in a jurisdiction that has private sector privacy legislation, an employer is limited to collecting only the information reasonable to determine a candidate's suitability for employment. In addition, obviously, an organization subject to private sector privacy legislation will need to comply with its other legislative obligations related to use, security, and disclosure of that information throughout the employment, hiring, and employment relationship. And I mean, in terms of use, for example, if you need to be collecting information for the use indicated. So if, for example, with respect to an employee, we're collecting health information or information about dependents of that particular individual, for example, for benefit purposes, we should not be then using that information to make other decisions with respect to that person's employment down the road. That information should only be used for the purpose identified and consented to. In terms of security and disclosure, also should be ensuring that, the personal information that is collected is secure, only accessible to those who need to access it, and only disclosed for the purposes identified and consented to. As an example of what not to do, we have this investigation of Mark's Work Warehouse out of Alberta in 2010. So the fact scenario here is that the complainant applied for a job with the company as a sales associate. In the interview, he was asked to consent to, among other things, a pre-employment credit check. The credit check was run, and apparently there were issues with the credit check because the complainant was called a few hours after the interview and asked to explain the credit issue as well as how he planned to resolve it. The complainant explained that the credit issue was the result of an error in the processing of paperwork related to his student loan, but due to his lack of financial resources, he couldn't put resources into resolving the issue. And the complainant was not hired. He filed a complaint that the collection of the credit information was not necessary given the job requirements of a sales associate. And the Office of Information and Privacy Commissioner launched an investigation into the complaint, which was made under the Personal Information Protection Act, or PIPA, in Alberta. During the investigation, the company indicated that its position was that the credit check was required to assess the individual's ability to handle financial responsibilities. The theory being that if a person couldn't handle their own finances, they would not be able to manage the financial responsibilities of the job. They also indicated the credit check was required to assess the risk of in-store theft or fraud, which it had identified as an issue with the organization. Now, in making its decision, the Office of the Information and concluding the investigation, the Office of the Information and Privacy Commissioner noted that a credit check could be influenced by factors outside of the individual's control, such as errors, which was the case here, as well as potentially even identity theft. And those things would have a negative effect on the individual in that the process of this employer, it would have them screened out of the application process potentially. The investigator commented there were less intrusive means of assessing those same skills, such as contacting the person's references and asking them questions during the interview. So ultimately, the Office of the Information and Privacy Commissioner found that the collection of the credit check information contravened PIPA because the information was not reasonably required for the duties of the position. And the organization actually accepted that finding and ceased the practice. In other jurisdictions, and by that I mean jurisdictions which do not have private sector privacy legislation, an organization may still want to limit the information required during the application process to only what is reasonably necessary to assess the applicant's suitability for the position. And one reason for that is that an overbroad request may increase the potential risk that the employer may contravene human rights legislation. So, I mean, collecting information with respect to age, race, family status, disability, or marital status, if they're not related to assessing the suitability of the person for the job, why would you ask for it? So keep that in mind going forward in terms of your hiring process. But what about an employee's duty to maintain the confidentiality of the employer's information? What about that? Well, an employee has a common law, and that means it's a judge-made law, duty to protect employer confidential information. And that duty of confidentiality survives the employee's termination for any reason. Now, what is confidential information? That will be a contextual analysis of your decision maker, but generally speaking, a decision maker will consider the accessibility of the information by others, the nature of the information itself, the manner in which the information is handled by the company, as well as whether the employee reasonably understood that the information was confidential. So that's the analysis that will be conducted to determine whether the information in fact was confidential. And although this common law duty exists outside of any written policy or employment agreement, the best practice is still to set out those obligations in writing in an employment agreement. And there are a couple of reasons for that. The first one is simply that if it is set out in writing, there is no confusion with respect to what the employer's expectations are. Your policy should define what confidential information is, and things like when it is to be disclosed, whether written authorization from the company is required, but it sets out the expectation so that everybody is aware of it. That's one way that a policy is useful. In addition, a policy should set out the potential consequences of breaching the confidentiality policy, again, so expectations are clear. And another reason is that, if there is a situation where there may have been or there has been a potential breach of confidentiality, you have the employer has a written document to rely on when discipline is being contemplated. Now, speaking of discipline, is a breach of confidentiality cause for termination? And I have two interesting case examples for you, one in the non-unionized context and one in the unionized context, where employees were terminated for cause for breach of confidentiality. The first one I'm going to talk about is this Steel and Coast Capital Savings Credit Union case. Now, in this case, it involved a 21-year IT department employee who accessed a manager's personal folder without permission. I'm going to give you a little bit more background so you can really get the context on this one. So this IT department employee was responsible for internal technical assistance, and as a result, was one of the few people in the organization who had access to every folder and file on their network. Each employee of the company was assigned a specific personal folder for their own use, and the folder was to be used for confidential information, both personal and with respect to their duties in the company. The employer had a very strict policy in place that one employee could not access another employee's personal folder without permission. And even when they had permission, there were really strict protocols in place. So just to illustrate that point, when someone called the IT department or this person for tech support, the first step was to try and resolve the issue verbally without accessing the folder at all. If they were unable to do that, then the IT department employee would take over the employees with the issues screen remotely so that that employee could see everything that the IT person was doing while in their personal folder. Again, even with access to the personal folder, before accessing a specific file, express permission was required. So this is a very strict policy protocol that they had in place. And the employee in this case accessed a manager's personal file, the court found ultimately for her own purposes. And it was only discovered because the manager was trying to access the same file at the same time. So completely by chance, but the manager whose folder it was actually locked out of accessing her own file. And it said that this employee was accessing the file at the time that she was trying to. So that's the only reason that this person was found out. Interestingly enough, the file that she accessed without permission was a employee parking priority list, which she was accessing, presumably to find out where she fell on the list. In addition to the order of priority for employee parking, that document also included other confidential information such as pay grade information. So the company terminated her for cause. The wrongful dismissal claim was dismissed by the trial judge, and the BC Court of Appeal upheld the trial judge's decision that the employer did have cause to terminate. And there are a few things that turned on, but I think what it's important to mention here is that the court considered that this particular employee was in a position of trust. Again, like I said, she had access to every file on the employer's system, and she worked generally without supervision and with autonomy. The court also relied on the court also noted that the employee had clear privacy protocols in place, which indicated and warned of what the consequences could be in the event of a breach. And ultimately, because of those things, found that termination for cause was justified. In the unionized context, now this is a particularly sad case because it involves the employee, in this case, was tasked with cleaning up a site where a patient of the hospital tragically committed suicide. This employee was told to go to the scene. When he originally got there, there was a crowd of people, including police officers and investigators and other people around, so he couldn't begin the job. But he took a photograph of the crowd, and then once the crowd dispersed and the body was moved, he had to clean up the area, and at that point took another photo of his glove and gauze and some markings on the ground. He then posted those photographs with captions to Facebook. This was seen by coworkers who promptly called him and said, "What are you doing?" So he deleted the photos, but his coworkers had reported the posting of the photographs to management, and the employer conducted an investigation. And during the investigation, the employee was dishonest in that he said he only ever took one photo and he had never posted the photos to Facebook. In addition, this particular employee did not have a clean disciplinary record. Ultimately, the arbitrator dismissed the grievance, upholding the termination. In this case, the union argued that the hospital's confidentiality policy was unclear in that the picture was taken in the parking lot and that the employee was not aware that the person was a patient of the hospital. The arbitrator commented that confidentiality of patient information is critical, and the policy of the hospital didn't need to particularize every specific situation that would result in a breach of the policy in order for the policy to be clear. And so ultimately found that the photos constituted a breach of patient confidentiality, even if the employee didn't know that the individual had been a patient of the hospital. He ought to have exercised due diligence. And again, the grievance was dismissed. So we've just gone over two circumstances, one in the unionized context and one in the non-unionized context, where termination was upheld for breach of confidentiality by the decision makers. And in both cases, it's important to note that the written confidentiality policy was considered by the decision maker as a fact that weighed in favor of the employer's decision to terminate. Another question that we often get is, can we engage in surveillance, or when can we engage in surveillance? And in a non-unionized setting, an employer does have more discretion to engage in surveillance. In a unionized setting, arbitrators have recognized that employees have a privacy interest, and that in order that an employee must demonstrate a reasonable basis for engaging in surveillance in the first place. And then once engaging in surveillance, that surveillance is conducted in a reasonable manner. and that there is no less intrusive way to get the information that the employer is trying to get. No less intrusive method than surveillance. So again, we have a few interesting cases on surveillance, and I'll start with in the unionized context. I'll start with Unite here in the Fairmont Royal York. In this case, 19 employees were terminated after a workplace investigation into the use of drugs and alcohol at work, among other things. This particular decision was with respect to the termination grievance of one of those employees, but also the union filed a policy grievance that the employer had violated the collective agreement by engaging in covert audio and video surveillance. So a little bit more background on how all of this started. So the employer gets reports from multiple employees that there are employees engaging in this type of, the use of drugs and alcohol in the workplace, trading food for alcohol. And so the first thing that they do is that they ask their security personnel to observe these particular employees more closely. And the security personnel don't see anything, but 2 weeks later, they get another complaint from an employee about this same group of employees. And at that point, that's when the employer considered whether to engage a third party to investigate the complaints. And then a bag of alcohol goes missing, and members of the security team observe employees engaging in potentially suspicious behavior on the company's CCTV cameras. So then they start to take steps to actually start an investigation. And they ended up having someone go undercover as a member of the cleaning staff. And they expected that it would take a while for this undercover investigator to observe anything, but it only took a couple of days. And those few days, the investigator was just observing. There was no surveillance video, but after the investigator indicated that he had observed misconduct, that's when the decision was made to start video surveillance. And that video surveillance included video evidence obtained in the men's change room. And those terminations were based in part on the video surveillance evidence that was collected by this undercover investigator. So in the grievance with respect to the allegation that the surveillance was a violation of the collective agreement, the arbitrator considered the reasonableness of the decision to engage in surveillance in the first place, and concluded that there was in fact a reasonable basis, and that was because there had been complaints from employees, the alcohol had gone missing, and the investigator's own initial observations before the video surveillance started showed that there was a reasonable basis to conduct the surveillance. With respect to once it began, whether the surveillance was conducted reasonably, the arbitrator found that it was, except for the surveillance that was taken in the men's change room. The video did catch employees in various states of undress, although that was limited. But in that particular circumstance, the arbitrator found that there was a less intrusive means to get the information. For example, the investigator could have acted as the company's eyewitness instead without taking the video footage. So in terms of the termination grievance of the particular employee, as a result of that, the employer was prohibited from relying on the video from the change room, but was allowed to rely on the surveillance from all areas outside of the change room. Another interesting set of facts, this again in the non-unionized context, Caldwell and Cornerstone Properties. In this case, the employee quit and alleged that there was a constructive dismissal after finding out that a secret video camera had been installed in her office and only her office. When she found out that it had been in place for months. When she had been an employee for 7 years and had no performance issues. Understandably, upon finding out that this camera had been in her office for months, she felt a great deal of stress and felt violated. So she asked the employer what was going on. Why was this video in my office? They responded that the camera was installed due to so-called thefts by maintenance staff. And there had been thefts, but none had been the employee at the time, the employee who is alleging the constructive dismissal, only knew about one of them, and none of the thefts had been from her office. She did not keep any money in her office. Again, the employer claimed that they had no issues with her specific performance. And the employee, and as well, if you read the decision, the court do not buy that explanation. If she didn't keep money in there and she wasn't suspected of the theft, why didn't she know about it? Why didn't she know about the camera? Why was it secret? I think at one point the employer said that they installed the camera because they thought the maintenance staff who were potentially engaging in theft might go into her office to, I think the words were, review the loot that they had stolen. Nobody was buying that explanation. So in terms of the camera, the court found that the camera itself wasn't necessarily unacceptable, but the implausible explanation rendered the employer's conduct unacceptable. The court found that the employee's privacy was breached, as was its duty of good faith and fair dealing. And because of that, the employer's conduct amounted to constructive dismissal. And as a result, she was entitled to 7 months pay in lieu of notice. So those are two cases that illustrate in the non-unionized and unionized context, the reasonableness of an employer engaging in covert surveillance. And that brings us to the end of the surveillance section. So I'm going to pass things back to Gerald to speak to you about intrusion upon seclusion.
Thanks, Natasha. Try again to unmute myself. One of the interesting things about the Caldwell decision is it's back in 2008. Remember, we've got no privacy legislation applicable to the private sector. And then also at that point in time, there was no recognized cause of action in dealing with privacy. All of that started to change in 2012 with the decision of Jones versus Sieg. So I'm going to talk a little bit about that decision, one which you are very likely familiar with at this point in time. And then I'm going to talk about how that decision has since been applied over the years and developed a little bit, so to get an understanding of how this is working out in practice. So first of all, Jones versus Sieg, we had two employees who both worked at the bank. And Sieg was in a common law relationship with Jones's ex-husband. So you have that personal component. And then Sieg at work accessed and reviewed Jones' private banking records and didn't just go and glance at it here or there or bump into the information or what have you. Instead, Sieg's actually accessed it 174 times. So we have a high level of invasion at a scale and magnitude that's quite significant. In response to this, Jones claimed that Sieg invaded her privacy. The court agreed. And then at the Court of Appeal, we have is the establishing of this new tort of intrusion upon seclusion. And glancing and looking at the details of this breach, the court says, first of all, we have privacy law that's been developing over the years. We have legislation. We have this whole context. And the facts in this case cry out for a remedy, the court says. So in this offensive context, we then have the development of this tort. And to establish this tort, it won't be any invasion of privacy that will trigger the tort and damages flowing from that tort. Instead, 5 elements have to be established. First of all, there has to be intentional or reckless conduct on behalf of the party. So not just taking the right steps and then coming across information. There also has to be an actual invasion into the plaintiff's private affairs and no lawful justification for doing so. The type of breach is also one that's going to have to be highly offensive to a reasonable person. So some of the examples that the course speaks to in that context are financial information, as well as, which is what happens in the case itself, medical information, and sometimes also private correspondence between parties. There also then has to be distress, humiliation, or anguish caused in order for this tort of the intrusion upon seclusion to be triggered. So that was the starting point for where we are. And then we've seen some cases come over the years, giving us a little bit of guidance about how adjudicators are going to address this tort in practice. The first example of a case I'll speak to is this Rancor Cairns versus the Saintqua Printing and Publishing Company Limited case, a decision out of New Brunswick from 2018. Here we have an employee who had accessed and used a company phone. And in using the company phone, there was access to an iCloud network. Also on the iCloud network, the employee had linked her own private account. So it was connected to the company phone, her private iCloud information. She goes on a leave of absence and returns her phone. Ultimately, her employment ends and there's a wrongful dismissal action that follows. When they get the phone before the action being commenced, they find in there a medical note that was downloaded and forwarded, and it was contained in the employee's private iCloud net storage place, but not on the and access through the phone, but not in the company's aspect of iCloud or on the company phone itself. The access was unauthorized. They weren't allowed to go and access that, but it was unintentional, not on purpose. And the court was asked to decide whether or not the medical note issue would give rise to the tort of intrusion upon seclusion. And in finding that it did not, the court looked at several key facts. First of all, the medical note would have been disclosed in the lawsuit. So doesn't reach the test of being highly offensive to a reasonable person. The access was unintentional, so we don't have that intentional or reckless conduct that's required. And the phone was examined for a lawful reason. Yes, they shouldn't have had access to that particular information, but the phone itself was there. They weren't phishing. They came across the information. So there in those facts, we have the claim for intrusion upon seclusion being dismissed. Another example of this being applied is this case of St. Patrick's Home of Ottawa versus CUPE. And this is an arbitration decision where we have an employee who's working in 2 different long-term care homes and initially is receiving some accommodation for a disability at the 2 different long-term care homes. And so the one long-term care home is looking at the medical, starts to question it a bit. Some of the restrictions don't really seem to add up, seem to be more maybe, the type of thing where an employee wants it rather than they actually need it. And so they say, oh, we know this person's working over at this other long-term care home, St. Patrick's Home of Ottawa. So let's call them up and let's see what they have to say to us about the disability and whether they're providing any accommodations to the employee. And with no malice and not intending to act in bad faith, the employer, St. Patrick's Home of Ottawa, did disclose the information, firstly, that she was not being accommodated at that point. And the reason for that was that she'd provided a medical note to this doctor or to this employer that said that she no longer needed those accommodations. And then after having that discussion, the employer followed up and gave the other employer the medical note itself that indicated that those accommodations weren't needed. And so the arbitrator looked at the facts here and noted a couple important things. First of all, it's a breach. The disclosure here is a breach of the confidentiality policy that the employer had in place, and also therefore a breach as well of the collective agreement itself. And so in this context, the arbitrator found that this was a breach of the tort of intrusion upon seclusion, and then turned the arbitrator turned to mind to the question of, okay, well, what do we do in terms of damages here? And the arbitrator said declaratory relief is not going to be enough. We need to do something to send effectively a form of a message beyond that about the breach. And so the employee was awarded $1,000 in damages flowing from the breach itself. Third and last case I'll discuss is a Rio Tinto Alcan versus Unifor case. And in this case, we have employees working out in a remote area of BC at a work camp. And they fly in by helicopter to get there to do the work. And the employer was concerned about the potential for things like drug use at the work camp. And so it hired the security personnel to come in and a sniffer dog to go around to employee rooms. So they go around, and one of the things that they find in their review is a firearm. Now and the reason that the dog caught is there was actually some residue blood on the firearm. That firearm was there lawfully. There was nothing inappropriate in of itself of having the firearm there. And so it was found that going into the personal residences or the rooms where these employees live in this matter without getting consent and simply going in and doing so was found to be a breach of the tort of intrusion upon seclusion. Now, central to both that finding and then the fact that there are damages awarded, which in this case were 17 awarded to each employee except one, and the one who got damages of $2,250, the one who had the lawful firearm in the room, was the fact that the employer at the arbitration admitted that they didn't deal with correctly, but otherwise took no other steps to address the fact of the privacy breach and to put any concerns about invasion of privacy from employees at rest. And so the lesson there is where we do have a potential breach, this case gives some guidance about the idea that we can be proactive in trying to address it where there is a breach, and that may lead to a different finding, at least in terms of damages, and potentially in scaling back a finding that the conduct is highly offensive and therefore giving rise to the intrusion upon seclusion tort. So I now want to turn and speak a little bit about some of the COVID-19 privacy considerations. And so right now, as employers, we're dealing with being asked to collect information, screening information. So I'm going to talk about that. A hot topic also of what we do with vaccination related information. Can we collect it? What can we do with it? And then lastly, what do we do with COVID-19 diagnostic information? So first of all, as I mentioned, obviously we're required right now in Ontario to conduct employee COVID-19 screening when people enter the workplace. And as part of that, we also need to retain that information. And from the Ministry of Health, the directive has been that we need to hold that information for at least 1 month. And so it's important that we do that. We'd also say a best practice is to hold on to that information longer past the applicable limitations period. So past 2 years here in Ontario, so that if there were a claim that were to come up at a later point in time, that we do have that information available to show what steps we took, for example, in the steps we took in collection and screening and those types of things. Where we are collecting those information, just like any other medical information or personal information we have, we want to make sure that that information is being maintained in a secure location and only disclosed to a third party if required by law. There may be times where we are asked, for example, by a public health official to provide that information, and we need to comply with those requests. We'd also say it's a good idea, best practice too, to get those kinds of requests in writing, so we're providing consistent with the demand from them and not facing allegations of overstepping our obligations in that regard. Now, let's turn now and speak a little bit about vaccination information. And so this is, as we move forward and vaccinations are now increasingly ready, available, and many workplaces working hard to ensure that their employees do get vaccinated. We need to, this is a question that's popping up. What can we collect this information? What can we do with it? So if we're in a province with provincial privacy legislation, so for private sector employers, that's not the case here in Ontario for provincially regulated employers, or in a unionized workplace, we need to establish that the collection of that vaccination information is reasonable. If we're in a non-unionized workplace, we don't have the same considerations in the same way, but we still need to consider what we will do if an employee refuses. So if an employee refuses to provide vaccination information, that may not provide, for example, cause to terminate an employee's employment. Or if we say you can't come to work until you provide that information, depending on the workplace context, as well as the public health situation, that could potentially give rise to a claim for constructive dismissal. So we need to think about those factors if we're in requiring that information. The collection may be appropriate though if we're providing an incentive to employees to become vaccinated. So we're giving them a bonus for getting vaccinated or time off. And if an employee, if we're an employer who is, our employees are able to get the IDEL paid sick time benefit, well then the asking for the record of the vaccination is something that we would need then to claim reimbursement for that paid IDEL day, and information about the paid IDEL days and whether that applies to you and how that applies can be found in our website. It direct you there if you have any questions about that, or to contact another member of our team. We want to ensure where we do collect this information that our vaccination records are securely safeguarded in the same way as any other medical information. And again, vaccination status should not be disclosed to a third party without the employee's consent. Now, turning to the issue of diagnosis, it's absolutely reasonable to request that an employee provide proof of diagnosis through COVID-19 test result. A way that we can do that is ask for a screenshot or a printout of the results of a COVID-19 test. Doctors note, first of all, perhaps only provide so much value, and then it's also a category of information under the Employment Standards Act about the diagnosis of COVID-19 that we can't ask for in the same way, and so we need to make sure that the best way to get this information is to ask for the test result itself. And the justification for requiring is it's reasonably necessary to take these steps to protect health and safety of coworkers and customers. The best practice, if we are going to disclose that the information is to about a COVID-19 diagnosis, is to obtain an employee consent, and then limit only to the people who need to know for contract tracing purposes. In a province with private sector privacy legislation, the disclosure of diagnosis to employees without consent may constitute a violation. As well, for a unionized employer, disclosing that information may be viewed as a violation of employee privacy interest, or of the giving rise to the tort of intrusion upon seclusion. And as I've mentioned a couple times now, in some circumstances, as an employer, we may have a legislative obligation to actually disclose COVID-19 employee information to public health and government ministries, and that's something that can arise under some of the regional class orders, as well as occupational health and safety legislation. And in these circumstances, employee consent is not required, but again, where possible, getting the request in writing is a good step to take before disclosing that type of information. So we'll now turn and speak a little bit about workplace policies. And so in some of the cases that Natasha spoke about, she highlighted this fact of how whether you have a privacy policy in place has been a big factor in terms of the success in litigation in being able to address privacy breaches in the manner in which we may want to do so. And a well-drafted policy, as Natasha indicated, can enhance the likelihood of discipline being upheld if an employee commits a privacy violation. It shows that, you know, we take the issue seriously. If we take it seriously as well and train employees about the boundaries of how things are to be disclosed and what to do, these are steps that also can help reduce the risk of an inadvertent disclosure of confidential information. We want to make sure that our policies are clearly written. We've defined what it is we're covering and how things need to be addressed. And then we also want to make sure that we bring the attention of the policy to bring employees' attention to the policy. And so often we may have really well-drafted policies, but they've been posted in a corner of the intranet the employee doesn't necessarily visit, or worse yet, stuck in a drawer in an office somewhere or in a file drive, not actually brought to the employee's attention. So we do want to make sure that we've done that. And we also want to make sure that we have evidence that we have brought it to their attention. And that can be done through things like if we're going to go the step of doing training, which in many contexts is a great step to take, that we've shown the training records, or that we have an acknowledgement of employees having read and understood the policy, and we can show that they should understand or do understand the nature of their obligations with respect to confidentiality. We also want to ensure in the policy that we state that a breach may result in discipline up to and including termination for cause, and that can be key language as well. We're making clear it's not just a termination without cause that can happen if there's a breach, but a termination for cause without notice. In the policy, we want to make sure we define confidential information. We don't want to make it so broad that it's meaningless, everything under the sun. And if there are specific categories that are particularly important to our business and that we need extra safeguards around, we want to make sure that we are addressing that specifically within our policy and bringing those issues to an employee's attention through the training, acknowledgements, and those types of things. We want to also outline when disclosure is permitted and who can waive confidentiality on behalf of the employer. We don't want to find ourselves in a situation where an employee says, well, you know, lead hand X said that I could go ahead and do this, disclose this based on some offhand comment. It's a good idea to designate certain people to be the ones who are permitted to waive that right. It may not be that a court will always find that that's necessary, but that certainly helps a lot in showing the emphasis on confidentiality, and that an employee should not have an understanding that they can just go off and disclose confidential information or suggest that they had some understanding of that nature. We also want to put employees on notice in the policy that confidentiality obligations will continue post-termination. It's important to remember that these obligations can, under our laws, persist indefinitely and continue on well past termination. Workplace privacy policies, there are, for employers in the federal sector here in Ontario, so federally regulated employers, and then employers in BC, Alberta, and Quebec, you must have a privacy policy to address employee personal information. In other jurisdictions, we don't have specific privacy legislation applicable to the private sector in the employment context, but still PIPEDA does require that we have a privacy policy to deal with personal information collected in the course of commercial activity, such as, for example, selling goods to a third party. Policies will need to be reviewed and revised if the new legislation, the CCPA that Natasha discussed, is enacted. So it's important that if and when that is enacted, we turn our minds to updating these policies to ensure they comply with the new requirements under the legislation. Some of the key elements we want to make sure we have in these policies, and as you is first of all, identifying what personal information is collected, the purpose for which we're collecting it, and to whom it will be disclosed. We want to ensure also that through these policies, we're taking the step of obtaining consent to the collection, use, and disclosure of that information, and ensure information is only used for the purpose that's identified. If we do think that we will use, or we are thinking about or going to use that information for a different purpose, the fact that we may need to then go and get consent because that initial consent only applied to the use for which we said we were going to collect it, use, or disclose it. We also want to ensure that where we have use of our technology at work, whether that be a phone, a computer, information systems, that whether we want to advise employees in our policies whether they should have any expectation of privacy, and whether or not that there is an expectation of privacy is something that will inform our ability as an employer to then go and look at emails, hard drives that are on or that are on our equipment. And if there is no expectation of privacy, then we can do so without concern. On the other hand, if there is an expectation of privacy, that may limit the extent to which we can look at some aspects of company equipment or company resources, even if they're ours and we own them. We want to identify how an individual can access and correct personal information and challenge compliance as well. For the policy itself, we want to ensure that there's an individual at the organization responsible for privacy and to answer any questions, and to outline procedures to retain and destroy personal information. And then we also lastly want to make sure we're identifying and implementing safeguards to protect access to and disclosure personal information, and that we're not just identifying them, but implementing them, making sure we are taking those steps that we say we're going to protect the health information or to protect the personal information of employees. So what can we do to help you with some of these types of issues? Well, first of all, we can advise, assist, and represent your organization in disciplining and discharging for breaches of confidentiality, as well as investigating confidentiality breaches and providing advice how to manage these things. We can also provide advice with respect to workplace surveillance, what's permissible, what's not, what's riskier, what are some steps we can take lawfully if we are going to proceed with surveillance, and what are the ramifications of not doing it in the correct way in terms of a legal proceeding. And then lastly, we can assist as well with the full range of agreements and policies, including employment and independent contractor agreements, confidentiality policies, privacy policies, and also assist with managing the collection, use, and disclosure of COVID-19 related information. And so that concludes our presentation. And with that, we're going to now start fielding some of the questions that you've sent across. And if you do have other questions, please do type them in the Q&A box. And I will ask Natasha first to start us off with some of the answering one of the questions that we've received.
Okay, so we have a few questions here. I think it makes sense to answer them sort of in the order of the topics covered in the presentation. So I'll start with the questions about the legislation. I have a question and I'll just read it out. Does PIPEDA apply to a nonprofit organization or religious organization? The answer to that is it will generally not apply if the organization does not engage in commercial activities which is the case for most nonprofit or religious institutions.
And it is important to recognize there too, as well, just to add to that, that just simply because an organization is not profit does not mean that PIPEDA won't apply. And there certainly are decisions that have been made where businesses that are, or organizations, I should say, that are nonprofit have been found for PIPEDA to apply to them. You know, the daycares, for example, that's been found to apply on at least one occasion. And so we do need to look at, first of all, what's the core activity of the institution or organization, and then look at the activities at issue and conduct an analysis there. Because just simply, and is it really a commercial activity? Are you selling something? Even if it is nonprofit, there may be a risk that PIPEDA is still engaged in those circumstances.
I can.
Oh, sorry. Yes.
I can address the next one. So the next question is: does PIPEDA apply to employee personal information? It will, but only for employees of a federally regulated entity. It doesn't apply to provincially regulated employees. They would be covered by any applicable provincial privacy legislation.
Okay, I may. So just switching gears to some of the things that I was speaking at. One of the questions that came across was, can an employer mandate COVID-19 vaccination as a condition of employment? So an employer can require COVID-19 vaccination as a condition of employment, but subject to a few specific considerations. So the first I'll talk about is human rights. So an employee unable to receive the vaccination due to a health condition or religious belief may claim that that policy is discriminatory. And as a result of that, an employer must be able to demonstrate that the vaccination is a bona fide occupational requirement for a particular position. And so we'll have to look, at the business itself and also the public health situation at that point in time, and must accommodate an employee unable to receive the vaccine for a human rights code related reason. And accommodation should be addressed in the policy. The second consideration or area is, it's different whether we're non-union and union. So talking first about non-unionized employees, while an employer can implement a vaccination policy in a non-unionized environment, it's still important as an employer to consider what to do, again, if an employee refuses to be vaccinated on the basis of personal choice. Depending on the nature of the workplace and the employer justification for requiring the vaccination, the refusal to vaccinate may not amount to just cause to terminate an employee. And in this case, the employee will be entitled to pay in lieu of notice, and in some cases, severance pay under the employment standards legislation. So while we could require it there may be a cost to doing so, again, depending upon some factors in the workplace itself. And then if we're looking at this in the unionized context, mandatory vaccination policy can be challenged on the basis that it's a violation of the collective agreement. And in this case, an employer will need to be able to demonstrate to the arbitrator that the policy is reasonable for health and safety reasons or other workplace factors. And the case law on the influenza vaccinations, where we do have case law right now on vaccinations in workplaces, suggests this is probably going to be a high threshold to meet, and a policy that isn't reasonable is going to be struck down. So we can, but there are human rights considerations we need to keep in mind. And in the non-unionized setting, we may be a cost for it. In the unionized setting, it may not be reasonable in some workplaces. Have to turn our minds to how risky it is, the people we're giving services to, and those types of things in determining whether or not it's something that's likely to be upheld.
Switching back, I have another question on PIPEDA. So the question is, unlike PIPEDA, does Bill C11 attempt to apply to provincially regulated companies in Ontario with respect to its employees? So the answer to that is no. If we see private sector privacy legislation in Ontario, that's likely where we would see legislation that applies to employee personal information for provincially regulated employers. Bill C11 is more focused on enhancing privacy protections in the course of commercial activity.
So one of the questions came up again about COVID-19 privacy information. So please confirm how many years that the COVID-19 screening information must be kept by the employer. You indicated 2 months for contact tracing purposes, but I missed the number of years for other purposes. So first off, there's no absolute rule, but what the Ministry of Health says is to keep the information for at least 1 month, not 2 months, 1 month for contact tracing purposes. However, from a best practice, we'd say, you know, if there is any concern about a potential lawsuit and weighing all those things, keeping the information until the applicable limitations period or likely applicable limitations period has expired is a best practice. So here in Ontario, that's going to be 2 years. So if we can store it for that period of time and then get rid of it afterwards, then we still have that information. And if the event, in the event down the road, some litigation somehow rears its ugly head.
Okay, I'm moving into questions on the hiring, surveillance, and confidentiality section. And I have a question about the Marks investigation. Were there any fines or consequences for Marks? Did the employee gain anything personally? So aside from the negative publicity of having this investigation made public, there was no fine or consequence for Marks. That may have been related to the fact that the company did agree to cease the practice of doing the pre-employment credit checks.
So another question about COVID-19 privacy information. So the question is, any suggestions for companies doing self-reported / passively screening? Example, have a screening post up at the entrance of work, employees read the post, and for any yes to the screening, they shall report to the concerned manager and shall not come into the workplace. So importantly, here in Ontario, we need to be doing actually active screening, so that simply report if there's an issue or problem is not permissible. And instead, we need to have a record that the employee has conducted the screening electronically or in person. So that's filling out a form online, the paper document, or through an online form or app or what have you.
Next question here. Does there need to be a bona fide reason to ask for a criminal check? In provinces where there is private sector privacy legislation, you will need to be able to demonstrate that there is a reasonable basis for the collection of that information. For example, there's something about the nature of the position that requires the employee to have a clean criminal record. Additionally, there can be human rights related issues engaged by the use of a criminal background check. In certain jurisdictions like Quebec and BC, an employer can only discriminate, in other words, decide not to hire, if the result of the criminal record check is related to employment. For example, if the person has a theft conviction and the person will be the company's accountant. In other jurisdictions like Ontario, it's okay to make the decision not to hire based on a criminal record check, so long as a pardon has not been granted and the offense isn't a provincial offense.
Okay, another COVID-19 related question. I understand we can't disclose vaccination info without employee consent to a third party. Can we report aggregated data without consent? For example, the X percentage of our staff are vaccinated. Can we tell that to everyone? And so where we're talking about percentages or numbers or what have you, and we're not tying it to any individual, there's no identifiable personal information there. So there isn't an issue with that. And that's something that's permissible because, again, we don't have it tied to the person. It's not identifiable, simply general or information not specific to anyone in particular and anyone's own individual privacy rights.
My next question over here is, can an employer collect diversity data to demonstrate inclusiveness within the workplace? That's a question that we are getting increasingly from employers. In most cases, to avoid any risk or concern from a human rights perspective, the best practice here would be to collect the information anonymously and voluntarily, and make sure that employees understand why the information is being collected, and that it won't be attributed to any identifiable individual. In some cases, employers look to third parties to collect this data and provide it to the employer to reduce any potential concerns that employees may have.
Here's an interesting one about video with people working at home. So can an employee, non-union, refuse to participate in video conferencing, Zoom, Teams, because they do not want their image / home, etc., used in that context? And so we think it's a reasonable requirement to have employees on screen, just like you tend to work. You show your face. That's part of how we interact with each other. And so it is a reasonable requirement to do that. You can tell them if they have a concern about showing their home and that sort of thing, to use a background on the Zoom background, a picture or what have you. If an employee continues not to comply, it's going to be difficult to assert that this is just cause for termination, and saying that not having to show your face is a unilateral fundamental change to unilateral fundamental term and condition of employment. It's simply not. It's part of the day-to-day that has always been the case. So no constructive. So the risk of a constructive dismissal there is very low.
Can we collect personal information about an employee after the offer is signed? So in provinces with private sector privacy legislation, it will need to be reasonable collection. In other jurisdictions, you'll still want to ensure that any information that you're collecting that could be related to a human rights-based ground is collected for a justifiable reason. For example, we often need age and family information for benefit administration purposes. Otherwise, while the collection itself may not run afoul of the human rights legislation, it puts an employer at an increased risk that an employee claims a later adverse decision, for example, termination or discipline, was based on this information provided, and that those adverse decisions were related to the human rights information disclosed. For example, a disclosure of a pregnancy or a disability. I think the concern is if there is no reason to, from an employee perspective, why am I being asked to provide this information when it has nothing to do with my employment? They must be doing something with it. So I think in order to avoid that situation where it makes sense to have a reasonable basis for collecting the information. I also just want to highlight that when we're just in reference to the previous question about diversity information from applicants, we also need to be mindful about specific restrictions with respect to the collection of that information based on human rights legislation. For example, in Ontario, an employer isn't permitted to request information on an application form about an employee's membership in a protected ground. So keep that in mind.
There's a question: if an employee who has been vaccinated insists that he or she won't work with other employees who aren't vaccinated, what are the ramifications? Can the vaccinated employee claim constructive dismissal? So an employee is unlikely to be successful in claiming constructive dismissal in these circumstances. And then if the employee does resign, they resign. Where we have these types of issues, probably best to try to educate employees as much as we can, and that may be part of the correspondence or exchange we have with an employee in response to that type of assertion. But it's very unlikely there would be a strong case for constructive dismissal in the circumstances where they simply don't want to work with other employees who aren't vaccinated.
Just again, also on the topic of constructive dismissal. So one of the questions about surveillance was in the Caldwell case, This was the employee who found the hidden camera in her office. How was the employee dismissed in the first place? So the employee wasn't dismissed by terminated by the employer in this case. She claimed that she was constructively dismissed, which is a little bit of a tricky concept, but basically she claimed that by installing the camera and providing this untenable explanation for the presence of the camera, there had the breach of privacy irrevocably breached the employment relationship, effectively ending her employment. So the employer had engaged in behavior that ended the employment relationship. That's sort of the tricky concept there, but the employer did not terminate her employment.
When hiring, would it be reasonable to ask the potential candidate their vaccination status? So where we're before the point of the contract of employment forming, we've got a little more latitude in that we can potentially make it a term and condition of employment that someone be vaccinated. It's not a constructive dismissal. There's no contract form. We can form the contract, so that's a requirement. But, and this is the big but, we still need to consider the accommodation for an employee who is not able to be vaccinated for medical or other human rights-based reasons. So if we are going to be asking those questions, we want to make sure we're also making clear what our policy is on that, and that we will abide by our obligations under the Ontario Human Rights Code to accommodate for things like disability and religious considerations when those are a factor or basis in why the employee is not able to be vaccinated.
With respect to surveillance, the question is, in terms of surveillance cameras, should we be disclosing the location of all cameras to employees to avoid claims like this? So I think we would say in most cases, if surveillance cameras are going to be used, disclosure of the existence of those cameras may reduce the potential for a claim, but we do still see claims in unionized workplaces in particular that relate to what the information that their surveillance is capturing is being used for, and whether it's reasonably necessary for that purpose, or if there are less intrusive means available to achieve the same result. For example, if it's a camera in a storage locker where it has been placed to reduce potential theft, that may be something that's defensible. However, a company may have more difficulty convincing an arbitrator that a camera on the production floor is reasonable to monitor performance, even if the employees know about it. In this case, they'll need to be able to demonstrate why a less intrusive means of managing performance review and managing performance wasn't available. For example, like the supervision of supervisors. The employer will need to justify its position that it could not achieve the same performance management through less intrusive means.
One question here is about whether there's any guidance on refreshing training or revalidating an employee's understanding of these policies, so privacy policies, confidentiality policies. So the best practice is to do periodic updates, particularly on policies that we think are of specific importance. Some organizations see that they need to do it every year, and that could be a good practice. We want to make sure we're not overwhelming and throwing 300 policies in front of employees and saying each one's got to be signed off on. That can undercut the purpose, but certainly we and the level of which we may do training, we might do a acknowledgement each year, and then perhaps more training on as time goes on. Or if we see issues where we start to see non-compliance, people getting lax with our procedures, then those, or we're facing a disciplinary issue. Geez, looks like there's a gap. People don't seem to be following it. We've got people going the wrong direction and complying with our privacy and confidentiality policies. Those are times where we might then say proactively, okay, let's do some training refresh on our policies. Another question, how can an employer have a good privacy policy that doesn't bring up the intrusion upon seclusion tort? That's if there's really offensive conduct on the part of an employer, something that may happen. There may be a claim for intrusion upon seclusion, but remembering the sort of 5 elements that we have in order to give rise to the intrusion upon seclusion, there's got to be, number 1, an intentional or reckless conduct, an invasion of the plaintiff's private affairs, no lawful justification, highly offensive to a reasonable person and causing distress, humiliation, or anguish. But as far as it relates to, invasion of a plaintiff's private affairs in particular, no lawful justification and being highly offensive, if we make clear in our policies about there being no expectation of privacy in relation to the use of our equipment and make that very clear to employees, then the fact that we come across that information or we view it on our equipment is something that we'll be in a better spot to say, no, this doesn't give rise to the tort because we told you that we were going to access this information, and this is not a privacy breach. You just simply decided to use our equipment in the same manner as someone maybe talking about private affairs loudly in a hallway, for example. That there shouldn't be an expectation of privacy in those circumstances.
I don't think, Gerald, do you have any more questions?
I don't think so. I'm just taking a quick look through the Q&A, but I think that's it that I can see. Yeah, so I think that I can see we've answered, I think, the questions that I found but if in some form or another.
Okay.
So at this point, I'd say thanks very much for everyone for joining.
Yeah, that brings us to the end of today's program. We hope you found it helpful. If we didn't get a chance to answer your questions, please, drop us a line. Our next HR review webinar will take place on Wednesday, September 22nd, 2021. The topic's currently in the design phase, but we'll send out the invitation in due course. If you're on our mailing list, you will receive a notification. If you're not yet on our mailing list, to receive our briefing notes, newsletters, and invitations to seminars and workshops, please subscribe through our website. It's the big red bar at the bottom of every page. Finally, we'd be grateful if you would fill in the feedback form that you're going to receive shortly in your email. Again, thank you for joining us. Have a great day and please stay safe.
Thanks, everyone.